I don't know you. All I know is that you have picked up a case from out of state. And well, give me a second and I will let you, but here, so we're not disputing the underlying charge. We're not fighting it. None of that matters. What we really here are all about is identity, right? Are you this person? If so, how do we get you back to the jurisdiction that you're wanted from? So here it says that you are wanted from Michigan, Washtenaw, Michigan.
Washtenaw County, yes.
Yeah, Washtenaw County. And it says here that you're wanted out of there for armed robbery. So I know that you're going to tell me it's little bunnies jumping in the woods. It's not that big of a deal, yada, yada, yada. But my primary concern is public safety. We have enough death.
This is a courtroom moment that spirals fast. A defendant with a serious past, a judge deeply concerned about public safety, and a legal battle over one key question. Can this man be trusted outside jail? With allegations involving weapons, probation violations, and threats toward a family, this hearing isn't just about bond. It's about risk, responsibility, and whether the system believes second chances are being respected or abused. Stay with us because what unfolds next gets intense.
Dismemberment and hysteria in Harris County as it is, and I don't want any more blood on my hands. You know what I mean?
Yes, sir.
Shh. So your lawyer is asking me to set you a bond, and I don't know, because if you're a public danger, I'm going to have a hard time doing it. Right?
Understandable, Your Honor.
Oh, Miss Chisholm's not even here.
She just jumped off because she was just up there.
May I speak, Your Honor?
Your lawyer's not here.
Okay.
So until your lawyer gets back, I'm not going to let you go. I'm going to bring you back out, but your lawyer's not here. I can't talk to you without your lawyer here. So I'll bring you back out here as soon as she gets back, and then we'll go right through the rigmarole again. Okay? Sorry. I didn't even realize she's not here. Mr. Thurman, you're back. Okay. So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
Right here, things take a critical legal turn. The judge is weighing two major factors that determine bond: flight risk and danger to the public. Now, armed robbery combined with lifetime probation is already a serious red flag. But what really escalates the situation is the pattern being described: multiple violations, weapons involvement, and prior charges stacking up. In court, it's not just about what you say, it's about your history of compliance. And right now, the prosecution is building a narrative that this isn't a one-time issue, but a repeated pattern. Question for you: should someone with repeated violations still be given another chance at bond?
He's on lifetime probation in Michigan.
Lifetime? There's such a thing as lifetime probation?
There is.
Yes.
Whoa.
So that Kate, well, I'll let you do the talking.
No, he did his time and he got out, and lifetime probation out of Michigan. So that's what's happened. I believe it got.
So how on what would, aside from like a murder case,
So he was
what
charged
would
with
garner?
murder twice, along with 2 armed robberies.
I wasn't charged twice for no murder.
It just shows up.
It just shows up
Oh, I was
twice.
about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions.
This is where the prosecution strengthens its argument significantly. They're not just pointing to past crimes, they're highlighting behavior while already under court supervision. That's huge. A GPS monitor and curfew are not suggestions, they are strict legal conditions. Violating them, even for work reasons, can still be interpreted as non-compliance unless formally approved. The mention of threats involving children raises the emotional stakes even higher. Courts take any alleged harm or threat toward minors extremely seriously. At this moment, the judge is no longer just hearing facts, he's evaluating risk in real time. And honestly, this is where many bond decisions are won or lost.
And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, even threatening to murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA, but I don't have the documents, which is why I can't present them. If there's an ICA hold, he's ineligible for a bond because that's an ICA hold. I don't have it, which is why I can't say, but if I get the documents.
Interstate compact agreement.
I understand. May I speak, Your Honor?
Of course.
Okay. After we talk about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though. So
I understand.
that. That's why he overlooked. He said, okay, it's fine. He said it was fine.
Quick question, is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've
It's
not
this month.
heard, okay, and then so there's not been a hearing on that yet, right?
No, but that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up as. I took the plea
What
deal.
are you on probation for?
The armed robbery conspiracy coming on armed robbery. I did 5.5 years, came home off lifetime probation. And to continue what I'm saying, so I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday, I still showed up to court and got locked up. So there's no flight risk in this whatsoever if I'm been showing up every single time.
Now we hear the defendant's side, and this is important. He's arguing consistency, showing up to court, cooperating, even turning himself in. From a defense perspective, that directly challenges the flight risk claim, and legally, he's not wrong. Voluntary compliance does carry weight. But here's the problem. Courts don't just look at attendance, they look at the full behavioral pattern. So even if he showed up every time, repeated violations, even if explained, can still create doubt. What do you think matters more, showing up to court or strictly following every condition?
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, and they give you a curfew
Yes.
and you don't abide by the curfew.
I was working, Your Honor. That's why the judge has extended, because they had my probation curfew time I forgot what time it had as, but I had started my new job because I came, got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge and he extended my curfew. He was like, okay, we've been working. I said, yes, I have documentation of new work. So I'll show all my documentation and he said, okay. So the stuff he's mentioning violations for, they're already been taken care of. So he's not stating that either. He said 2023 is, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. I came with legit paperwork.
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge and that's why he's not been revoked. So he's still here. As to the underlying charge, it's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was going to get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taking care of what he needs to take care of, and he will still be here he's been on bond on the underlying case for about a year. Your Honor. He's not been locked up this whole time up until this recent arrest. So, and at this point in time, this is really just for if since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Texas Code of Criminal Procedure 17.03. NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy, 2021. Probation transferred to Texas 3/20/21. Concurrently charged with murder, which was dismissed. No holds. Defendant is not indigent, and defendant is alleged to have gone to complaining witness's home and pointed a gun at complaining witness and complaining witness's 3 children because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife.
This is one of the most damaging moments in the hearing. The judge is now reading the specific allegations: a gun, a confrontation at someone's home, and threats toward an entire family, including children. Whether proven or not, these details heavily influence bond decisions because judges must act on potential risk, not just proven guilt. Notice the judge's tone shifting here. This is no longer just procedural. It's personal responsibility. Judges often think, if I release this person and something happens, that's on me. That pressure is real, and it's shaping what's about to happen next.
That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, you know that you're supposed to be out there with a halo over your head. And yet you pick up an aggravated assault with a deadly weapon where allegedly a gun is pointed at kids. I mean, the way your mannerisms.
I would say something, Your Honor, that's why.
But don't, though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man. And you got to understand that I don't know if you're guilty of this offense or not, but the problem is bad stuff keeps happening to you for some reason. It's like sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. Mr. Thurman, you scare me, man.
This exchange becomes deeply psychological. The judge openly says, "You scare me." That's powerful and rare. It reflects a perception issue, not just legal facts. Meanwhile, the defendant pushes back, pointing to a year without trouble. Here's the tension. The system expects consistent lawful behavior, not periods of improvement followed by new allegations. The judge even uses a metaphor, people becoming their own worst enemy. That's a clear signal. He sees a pattern of relapse into trouble, not a clean record. Do you think the judge is being fair or judging based on past bias?
Yeah, scare you, Your Honor.
Yeah.
And I've been out for a whole year since this case happened, and this is my first time being into this courtroom again, and you're fearful for whose safety if I've been doing nothing but right and working.
That's not true.
That has been true. I've been out for a year on bond, and I have not been into this no courtroom, but in Orange Jumpsuit, I should say. Your courtroom, anybody's
You want
courtroom.
me to reward you for being
I'm saying, but you say you're in
person?
fear. You say you're in fear for safety. That's what I'm saying. Like, who are you in fear of? I have not been into
You're-
any trouble whatsoever. I've been squeaky clean. Just I bonded out.
And Your Honor,
You don't get rewarded for being a good person out there. You know what I mean?
I
You're
understand.
supposed to be like that anyways.
I understand that wholeheartedly, Your Honor. I'm just saying, but you say you fear, and I'm saying, how are you in fear if I've not been doing anything? That's showing you. That should show you some type of sign. Like, okay, he's never doing anything wrong. So where is the fear come to play? That's what I'm asking you.
The fear is really because, when people come here, it's little bunnies jumping in the woods, rainbows, gumdrops. And then when they get out there, they turn into different people. It's like Jekyll and Hyde. And I don't want that. Like, I don't want I don't want someone out there to suffer because we let you out, I let you bond out. You've got an armed robbery, you've got an ag assault, you continue to violate conditions on those bond, right? That shows me that you're not willing to abide by bond. I mean, quite frankly, you're lucky to even be out on those charges with the ankle monitor, and you continue to violate.
Your Honor, you keep saying violate, like, if I was in violations they have on file, by the way. Those have been taken care of. Once again, you keep on saying violations, but they took care of. The felony court judge seeing I have proven, what's the word I'm looking for? Just proven, facts that this is why I'm late. I have a new job. I got fired because I got arrested from the other job. So I started a new job. For me having a felony in my position, and just call it what it is, a young black man with a felony, it's hard for me to get a job anywhere. So the jobs I do get, I take up on those. So it's hard for any shift they open up for me, I'm going to take it and show my work ethic to them. So I let the judge know that. He sees that. He understands, like, okay, that's why you keep on bringing up violations. I have to work. I have to eat. I have to have a house to live in, like anybody else here. So you keep on bringing that up. I'll keep saying, I already talked to the judge about it. He granted it already. He let it go. That's why I'm still free to this day. Well, was free to this day. And you keep bringing that up. You saying threat to your fear, which is understandable. Everybody gonna have fear, but I have not been into any trouble. I've been working. I've been working for a whole year. I've been on my P's and Q's. And like you said, the police report that you're reading, sir, the case is still open, so I can't really speak on it. I'm pretty say much, but it's a lot more to what you're just reading on that police report. It's always gonna be video cameras and house ring cameras, body footage. It's gonna be a lot more other things that you're not gonna be able to read off a police report, which is understandable.
Just too much blood, Mr. Thurman. I'm sorry.
And here it is, the decision. The judge denies bond, stating there's too much blood. That phrase isn't literal, it's symbolic. It represents accumulated risk, past behavior, and serious allegations all combined. Notice how emotions rise immediately after. The defendant feels unheard, emphasizing his effort to work and stay out of trouble. This moment highlights a harsh reality of the legal system. Intent and effort don't always outweigh perceived risk. Once a judge reaches this level of concern, it becomes incredibly difficult to reverse that perception in the same hearing.
I can't set you a bond.
Sorry.
It's just too much. I'm sorry. Hey, this
You
isn't.
do not walk away.
This isn't.
I said, okay, it's fine.
Really. I understand that you're hurt, Mr. Thurman, but look,
I've been doing my best, Your Honor. And y'all sit here telling me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble. And you're a threat, and I'm a threat to society. Really? For a whole year I've been out, and they just not issue a warrant for me just now recently, and I come to turn myself in, and I'm a threat to society. And people, you fear me for what? From turning myself in and show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But y'all are a threat. You can let go of me, sir.
Stop.
You can let go of me.
You don't not tell me how to do my job.
Just you can let go of me. Grab my arm too tight.
guys, relax.
I'm too tight. All I said, grab me. Look how you grabbing me up.
Back up.
Look how they grab me. I said, you let me go a little bit.
You gotta calm down.
I'm calm. I just asked him a question. I asked him why she let me go a little bit, sir. That's all I said.
Open the door.
That's all I said. When you make somebody cuss you out or anything. You said I'm all tight. You just look. You know what I'm saying?
So he already waived, so if
He did.
holds it, then it.
Just, yeah, I
Yeah,
can't.
I'll go talk to him, but once again, Judge, understandably, I think I know that he's frustrated. I believe.
I understand. I get it. And I would be too, but I can't. That's just too much blood. It's too much.
It looked like there was.
Even, what I'm going to tell you, even if he didn't have those bond violations, I'd still be very hard pressed to even,
No, and I was curious because when she brought it up, it was a little bit older, and so I was wondering why.
are they going to come get him?
Oh, they're gonna get him. I was trying to figure out why now, and they were just having back and forth.
But here's the problem. So he hasn't made bond on those cases. So we're sitting anyways.
Yeah.
He has not?
No.
He said he did.
No, he's not made bond on those cases. He's
He's been in jail for a year?
No.
He may have, but they revoked the bond.
Ah,
Yes.
So he's sitting there, and I
There you go.
didn't have the heart to tell him right now that the 14 days is not going to apply.
Yeah.
Because
I gotta do that.
Well,
I will. Really.
I would
I
imagine.
will. I'll let him know.
I'd imagine it's gonna get resolved because it's one of those. It's a bizarre. So we revoked Harris County revoked because Michigan revoked because it was charged with the ag assault. So it's a chain of events because the only thing the court sees is that they revoked
So-
on the probation, which was caused by.
Please let him
events.
know that the 30 days hasn't kicked in and it will not.
It will not kick in.
Resolves.
Right.
And either he resolves the cases.
So which
Okay.
one does he need to resolve first in order for,
Well, for the felon possession of the weapon, there's, hold on, I don't want to.
Is there an offer?
No, it's going to trial. That's why it's been reset out. It's been set for jury trial at least
four
Really?
times?
4 times.
Yeah.
1, 2, 3, 4, 5. Yeah.
5 times, Judge.
Next time is January 6th, 2025. But he's held on 55,000 bond for the ag assault and 55,000 for the felon possession. So he has to come up with 110,000 for.
Wait a second. So
So it doesn't matter what you did today.
can't,
Right.
even if I gave him a bond today, he would still have to make those bonds.
110,000.
So my question now is, when did that warrant for the felonies pick? Because he's saying he's been out for a year ever since this
I'll
ag
explain
assault got picked up.
I show a remand defendant custody on November 18th, but I don't know what the previous.
So the only reason why his felony bonds got revoked was because Michigan
Well,
revokes.
I should
Oh,
say
no,
only.
it doesn't, but we don't know that for sure.
Yeah.
Because there's no notes that reflect why they revoked the bond. It just says court directive remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay,
Is remand to custody, violation report, but that's not a revocation. Yeah, because,
it's a violation report from Michigan?
no, for me, so remember when I said the newest violation was on November 1st for all the curfew violations?
Mm-hmm. Is that from here?
Technically, that could be the reason why they revoked instead of.
Let's break it down. This case centered on one key issue: risk versus trust. The judge ultimately denied bond because of multiple factors: serious prior charges, alleged violent behavior, repeated violations, and concerns about public safety. Even though the defendant argued compliance and effort, the court focused on the overall pattern, not isolated actions. This is a powerful example of how bond hearings aren't about guilt. They're about probability and protection. So now we ask you, did the judge make the right call, or should the defendant have been given another chance? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.